In the rapidly evolving landscape of artificial intelligence, a pivotal question emerges. Are AI models that train on copyrighted content infringing on the intellectual property rights of the original creators? This question not only stirs legal debates, but also challenges our understanding of creativity, ownership, and innovation in the digital age. On one side of the argument, there's a compelling case that AI models, by ingesting and learning from copyrighted materials, are indeed violating the rights of original creators. Think about it. When an AI learns from a book, a song, or a piece of art, isn't it essentially borrowing the creativity and effort of the original creator without permission or compensation? This viewpoint hinges on the principle that copyright law is designed to protect the original works of authors, artists, and other creators from unauthorized use. By training on these works, AI models could be seen as bypassing these legal protections, effectively copying aspects of the content in a way that could be deemed unauthorized reproduction. Conversely, there's a robust argument supporting the notion of fair use in the context of AI training. Fair use, a critical component of copyright law, allows limited use of copyrighted material without permission for purposes such as criticism, comment, news reporting, teaching, scholarship, or research. But does AI training fall under these categories? Proponents of AI training argue that the process is akin to research and educational use. The AI does not replicate the copyrighted works, but rather learns from them to create something entirely new and often transformative. Isn't this the essence of innovation and progress? Determining whether AI's use of copyrighted material constitutes fair use involves a delicate balancing act, considering factors like, we first need to look at the purpose and character of use. Is the AI's use of the material transformative? Does it offer something new or just replicate the original work? Next, what is the nature of the copyrighted work? Are we dealing with a purely factual work or a highly creative one? And what about the amount and substantiality of the content trained on? How much of the original work is used by the AI? Is this amount necessary for the AI's learning process? Last, what is the effect on the work's value? Does the AI's use of the material diminish the market value of the original work? So how do we balance the rights of original creators with the need for technological advancement? Can AI create a new form of art or literature that genuinely transcends its training material? Finding a middle ground requires nuanced solutions. One approach could be the development of clearer guidelines or licensing models specifically tailored for AI use of copyrighted material. Another possibility is fostering collaborations between AI developers and content creators, ensuring mutual benefits and respect for intellectual property rights. As we stand at the crossroads of AI innovation and intellectual property rights, it's clear that there's no one-size-fits-all answer. What's crucial is fostering a dialogue that respects both the sanctity of original creation and the unstoppable march of technological progress. With all of the above in mind, I believe the trajectory of legal trends and public policy considerations suggests a progressive approach favoring AI's ability to use copyrighted material. Historically, copyright law has evolved to balance the rights of creators with the public's interest in access to information and cultural development. This evolution reflects an ongoing recognition of the dynamic nature of technology and creativity. Looking forward, AI stands at the forefront of innovation, promising advancements in education, healthcare, and various other sectors. To impede its development by strictly enforcing traditional copyright norms could be counterproductive, potentially stifling the very creativity and innovation that copyright law seeks to promote. Embracing a more flexible approach, one that aligns with the transformative nature of AI and acknowledges its immense potential for societal benefit, seems not only logical, but imperative. This approach would not undermine the rights of creators, but would require a reimagined framework that supports both the protection of intellectual property and the advancement of technological innovation for the greater good. Now, as a creator, business owner, consumer, and listener, where do you stand on this spectrum of opinions? What solutions do you think could bridge the gap between protecting intellectual property and promoting AI development?